Hello, everyone, and thank you so much for joining us this afternoon. My name is Nina Holatova, and I am a lawyer and program coordinator at the Community Legal Education Association, also known as CLEA. For those of you who aren't familiar with what we do at CLEA, we are a nonprofit charitable organization, and our mission statement is unknown rights are not rights at all. We have been working to improve access to justice by providing education, information, and other resources to Manitobans about their rights and the law. And we have been doing this since 1984. So this means we are very much looking forward to celebrating CLEA's 40th anniversary next year. We offer webinars every spring and fall on a variety of topics. And today's topic is estate administration, what happens when there's no will. Just a couple of pieces of housekeeping. Today's presentation is being offered in webinar format, which means everyone is muted and cameras are off by default. We will have a dedicated time for some questions at the end. But as always, do feel free to send your questions during the course of the presentation by using the by using the Q&A function. However, if you do have a more specific question that pertains to your particular legal situation, I encourage you to reach out to CLEA's Law Phone-In program to speak with one of our lawyers for free. I also kindly ask that everyone completes our very brief survey after the presentation today. As a nonprofit, feedback from our participants helps us improve the quality of our programs going forward, and it is also invaluable to our funders. With that being said, I would now like to introduce our presenter, George Derwin. George Derwin has a Bachelor of Arts degree from the University of Manitoba and a Bachelor of Laws degree from the University of Manitoba. He was called to the bar in 1987. George assists clients in many areas, including corporate and commercial law, real estate, wills, and estate planning. He has substantial experience dealing with competency issues through powers of attorney or committeeship applications. George holds certificates in mediation and negotiation from Harvard Law School Program on Negotiation and has appeared in all levels of court, including 2 appearances at the Supreme Court of Canada. George has served as Deputy Public Trustee for the province of Manitoba, responsible for protecting the rights and liberties of all mentally incompetent and vulnerable adults in Manitoba. He managed $118 million in trust assets. George also has extensive experience dealing with intestate succession issues. We are so pleased to have him here today, and without any further ado, I will share the PowerPoint here and I will pass it over to George.
Great. Okay, so the seminar today is what happens when there's no will. So we're talking about the issues of intestate succession. So before we get started, if you do have questions, feel free to throw your questions in the chat. But I would ask that you not have personal questions. We all have our own personal issues that we deal with, but this presentation, it deals with general legal information and is not there to provide a specific legal advice to any one person. But if you do have a specific question, do feel free to call CLEA's Law Phone-In program, or if you have a question about the presentation that you want to ask me directly, feel free to call me. My number is 204-782-7056. My number's on the bottom of the slide, and I would be pleased to speak to you if you do have a question about this. So we're going to go through a number of things about what happens when there's no will. So I'm going to talk firstly about some terms and definitions in the trade, because it is important to understand the terms when you're speaking to a person or a lawyer about it, because it's you've got to get the terminology correct in order to communicate correctly. We're going to talk about the difference between probate and administration. Then we'll discuss the legalities of what happens when someone dies with no will, including such things as will invalidity. I'll talk about handwritten wills, Intestate Succession Act, Marriage and Common Law, Separation and Divorce, Family Property Act, Homesteads Act, Dependents Relief Act, discuss what it takes to file for administration when there's no will, and discuss a bit about estates under $10,000, and then we'll end with discussing the various fees involved. So let's get rolling on, first of all, some terms and definitions you should know about. The next slide, please. So anyways, so before we launch into that, it's important to understand that the term estate planning, we talk about that all the time, but estate planning is much more than just doing a will. It has to do with planning and management of your estate while you're alive. So there could be things like power of attorney or healthcare directives or comiteeship for mentally incompetent people. There could be trusts in person's lifetime or guardianship of children. And then, of course, the matters after death, doing the will. And in intestate succession, which is what we're dealing with today, so the term intestate means to leave with no will, and that's and that also includes a lost will or an invalid will. Next slide, please. So, in Canada, we have half of all Canadians have no estate plan whatsoever. It's growing because as our population ages, the sheer numbers of people dying without wills is increasing, and it's a somewhat, and you will see in our presentation, it's a somewhat cumbersome issue to deal with, and people should always have a will. Even people, young families or people with small estates should never overlook the importance of an estate plan, because if your estate is small, you can cost thousands of dollars out of from a percentage perspective, a lot of money out of an estate. I've seen people spend 10% of their legal fees or estate value on legal fees. So it is important. Okay, next. So to look at some terms of the trade, a will, we hear about last will and testament. Everybody writes last will and testament. It says on the tops of my dog, if you get a will from me, it says last will and testament. Testament is an archaic term. Will used to deal with just real estate. Testament used to deal with personal property. The Wills Act of Manitoba just creates the term will. That's it. So will, that's just a simple written document executed in accordance with the Wills Act of Manitoba, explaining how somebody intends to distribute their estate. And the Wills Act requires 2 witnesses to a will if it's if it's typed up or entirely in the person's handwriting if it's to be written out without a witness. So a testator is a person who makes the will. Testate means the person died without a will. And intestate is when a person dies without leaving a will. Next. So we hear about probate, and probate is used quite loosely, but there's a technical difference between probate and administration. So probate is when a will is filed in the court and the court issues probate. Administration is when there is no will. There's some other technical things, but for the scope of this presentation, I'm not going to deal with administration when there's no executors. So an executor is the person who's appointed under a grant of probate to carry out the directions set out in a will and distribute the property as set out in that will. Whereas an administrator is a person who's appointed under the letters of administration issued by the court, and they administer the estate for the person who died without a will. There's also circumstances where the person has a will but has no executors appointed, and that would also be a form of administration. But we're not, for the purpose of this, we're just going to talk about no will. Next. So one of the things that's really important to realize in terms of the difference between a probate and an administration is that if somebody has a will, the executor has the power to act at the moment of death and even can act before obtaining a grant of probate. In fact, we have if you can do an estate plan properly, it may not even be necessary to file for a grant of probate. You would have a non-probate estates where you can actually deal with the estate just using the signed will as the authority to deal with banks and MPI and Canada Revenue Agency will accept a notarized copy of the will without the necessity of having it being probated. So you can actually deal with an estate with a will without even having to probate it. But if push comes to shove, so for example, if you're dealing with real estate, real property, Registry of Manitoba, the Terranet requires a grant of probate to transfer real estate. Banks with sizable accounts. Royal Bank is very sticky. If no matter what the amount is, they would want the will probated. So you can act with a will before probate, whereas with no will, there's no authority. There's no one there who can act, and that estate can sit for a long time until somebody steps forward to do something. I've seen estates where no one has ever stepped forward. I've seen estates where it's been 10 years before somebody has stepped forward. Okay, next. So if a person dies without a will, in other words, intestate, in Manitoba, the Intestate Succession Act sets out a regime for distributing the estate, and the court supervises, loosely supervises the direction of the distribution, and the distribution itself is constrained by various laws in Manitoba. I briefly mentioned that in the instruction. Primarily, it's the Intestate Succession Act, but the Trustee Act also applies, and the Court of Queen's Bench Act and rules apply, and there are other statutes such as the Surrogate, Court of Queen's Bench Surrogate Practices Act. Next. So if somebody dies without a will, what happens? So first of all, somebody's going to have to apply to become administrator of that estate. Because it's a court supervised process, only a Manitoba resident may apply for administration of an estate. So for example, I had a case where a lady in Manitoba had 6 children, and all of the children were living outside of Manitoba, in Ontario, British Columbia, Alberta. And when she passed away without an estate, and the family wanted, the kids wanted to apply for administration, and I had to break the news to them that they could not apply for administration. They would need to have somebody step forward. And it was a question whether or not they were going to nominate the public trustee to do it or nominate my office to do it. And ultimately, they agreed to nominate me to do it. But it was a fairly cumbersome process to have all these people nominate somebody in Manitoba. The only time a non-Manitoba resident can apply for administration is under a summary administration of estates if it's less than $10,000. But generally, the rule is you can't apply, period. So the prohibition is really inconvenient, especially today with the mobility of families. Small estates can be very costly to administer. So because there can be bonds, there can be there's a surety that has to be obtained. So if you need to get an insurance policy for the administrator, that could cost $1,200-$1,500 a year to pay for, and that's coming off the top of the estate. The other thing is, if there's, in order to get rid of that bond, there has to be a court application, which again costs money. So the administration of an estate that's small in proportion to the estate is very cumbersome. So if you had a will, the executor just applies, and it's just a lot cleaner to do. And as I mentioned earlier on, an estate can sit for years and years before an administrator steps forward. Sometimes it can be because of a family dispute. Sometimes there's just nobody has the wherewithal to do it. I've seen all sorts of reasons why it doesn't happen. Next. So if there's no will, there's a lot of shortfalls that can occur. So if somebody dies without a will, there's no ability, there's no naming of guardians for young children. Now, technically, a will does not mandate who the guardians are. It's just it's a direction. The children are always under the supervision of the court, and it's the court that ultimately makes the declaration as to who the guardians would be for the children. but the parental wishes are very, very persuasive. So if you wanted somebody in particular to act as a guardian of your children who are under the age of 18 and you failed to name them, well, once you pass away, anybody can step forward, and whoever makes the best case to the court would become the guardians, and it would not necessarily be the person that you had wanted. The other thing is, if there's no will, there's no provision for an administrator to set up education funds or special trusts for children under the age of 18, nor is there an ability to create disability trusts or deal with special needs of children. Now, it's not to say that that disabled people are totally out. There are things like under the Employment and Assistance Act where there are disability trust provisions for people receiving inheritances, but that's under a statute that, and again, that's not a true trust. It's just inheritances held for disabled people, but you can't formally set up a discretionary trust. So if somebody is disabled and they receive an inheritance under an intestate succession proceeding, that money would actually be taken by social assistance and applied towards the needs of that person. We create discretionary trusts and wills to avoid social assistance from scooping that money. Ontario, they call them Henson trusts. In Manitoba, we call them discretionary trusts. So not creating a disability trust for a disabled person can have tremendous financial impact on that person's life. And then there's no ability to make any gifts or charities. So if you had a favorite charity and you died without a will, the administrator has no power to make any gifts. There might be specific friends that looked after you throughout your life that you were very close to, or godchildren that people are very close to. Those people, there's nothing that the administrator can do about it. No matter how much the administrator wants to do something about it, it's not going to happen because the statute constrains what the administrator can do. Next. So continuing on with this lack of authority or the constraint of authority, annuities and trusts. So addictions can often be an issue in families. Gambling addictions, we see fentanyl problem where families are terrified about giving their kids their entire inheritance at once. Because they're afraid their children are going to kill themselves because of their addictions. And I can tell you that a lot of families that is a very genuine and real issue. And with we had one estate, we had a kid got $330,000 on an estate. The money was gone in 10 months on cocaine for himself and his buddies. Okay. Very sad. So if somebody has an addiction, we usually will set up an annuity to give them enough money to live on, but not enough money to kill themselves. The other thing is there's no way to deal with assets of sentimental value. There can be certain family heirlooms that would go to certain family members, but again, the intestate succession laws just talk about division of money. That's it. The other thing it doesn't deal with are out-of-province assets. So if you have, because the Intestate Succession Act deals with what's in Manitoba, it ends at the provincial border, and you've got to go to the other jurisdiction to deal with the intestacy there. The other thing is that the administrator has limited power to make tax elections and can't take advantage of any tax planning devices. Now, this just happened to me. I had a client who had a lot of money. He died in Ukraine, and he has a child under the care of the public guardian and trustee. We had the accountant do a sophisticated tax plan that was going to net the estate hundreds of thousands of dollars in tax savings, and we had meetings and discussions with legal counsel of the public guardian and trustee, and they said we just couldn't do that. There was a tremendously advantageous tax plan, and we couldn't do it for legal reasons. So had they had a will, we could have saved the estate hundreds of thousands of dollars. Next. The other thing is, if there's no will, who's going to look after your estate? The person that steps forward may not be the person that you would like to look after your estate. Um, a will, you choose who the appropriate person is, but whereas in the intestate succession laws, it goes by degrees of consanguinity. So the in first order, it would be spouses would apply for each other. Then after that, it would be siblings, which would have an equal right to apply, assuming that they're in Manitoba. And then it goes down from there, grandchildren. And then if there's nobody around, even a creditor could apply. But the court's going to look at the degree of consanguinity. And we see rifts in family. We hear families talk about a sibling who's got some honesty issues or competent or incompetent in dealing with money, and that's the person who's often first there to make that application. So it doesn't help if you have the wrong person administering the estate. So the other thing is the intestacy rules, and you can gather from when I talked previously, they're inflexible and they're complex. One of the things is that when we would get distributions of to multiple family members of different degrees of consanguinity, different, so you have aunts, uncles, etc., in an intestate succession, the distribution regime can be so complex that when I was with the public trustee's office, we would tell lawyers, phone us and we'll work with you on how to do the distribution correctly. It's that complex, and I'm not even going to get into it in this discussion, because we could spend a whole hour talking about some of the niceties of how the Intestate Succession Act distributes funds, because it looks simple at first blush, but it's actually not. Okay, so this is, again, I'm going to repeat this again. The estate's not going to be administered until such time as somebody steps up to the plate to do it, and that could be a long time. Okay, next. So I just say we already covered that. The person doing it might not be right for the job. It's costly and cumbersome to administer without a will. Okay, there's certain things that the will can provide for. It's just clunky to deal with. I mean, you've got to figure out who's what, who are these relatives. I've got one file where the administrator who stepped forward has no idea where these relatives are and where to find them. And there's somebody in BC, he's got a first name and that's it. Like, so now he's got to hire this company to go and track down somebody with a first name based on a little bit of information. Just horrible to deal with, and it cost a lot of money to find this person. So the other thing is, you can a court, you may need to do a formal court application to appoint administrator. If there's, say, two people want to step forward and there's a competition between the two of them, you might have to file a formal application in court and have the court decide who is going to do the administration, or maybe both, or maybe the court might choose, might say another person is good, and ask the public guardian and trustee to step in. And the other thing is, and I mentioned this at the beginning, the administrator may have to purchase an expensive insurance bond, fidelity bond, an honesty bond, whatever you want to call it. But they can run $1,200, $1,500 a year, and you're stuck paying that premium each and every year out of the estate until the court releases that. So when you're finished wrapping up the estate, you have to go back to the court and say to the court, could you release that insurance bond? And then once you get the court order, you then have to send a copy of that signed court order, and it takes time to do it. So you've got to act fast. So if the court is I've had the court take sometimes a couple of months before I get an order back. Well, then all the whole time you're doing that is you're paying this premium on this insurance. You could be paying $200 a month on this insurance or more. Next. Okay. In an intestacy, minors get their entire inheritance at age 18. But before age 18, where does that money go? Well, under a will, you would have the executor would also be asked to be the trustee and hold that money for the children until they reach age 18 or whatever age you might want to choose. So under a will, especially with a substantial amount of money involved, a lot of executors will say, or people writing their wills will say, I want my children to receive their inheritance at age 21 or 25 so that they're not going to be irresponsible when they get their money. I mean, I know personally, if I was age 18 and I received a large inheritance, I would have done something really stupid with that money. I mean, we're not the most worldly people of that age. But if there's no will, you can't hold the money back. So you have a kid who's going through a lot of difficult times. Some people take a long time to mature, and you can't hold back the money in a trust until that person reaches an age where they're not going to be silly with their money. Well, with no will, too bad at age 18. So that money sits with the public guardian and trustee until the person turns age 18, and then they just get it all. And it's not uncommon. I've seen many kids go through that money in a matter of months. The other thing is if you have a trust under a will, you can give out money to that child for various things like education or other reasonable needs that child may have. But if you have the money in an intestate succession situation, that money is locked up until that child is age 18, unless you go to court and get a court order saying that the child needs the money for a certain purpose. So it's a very cumbersome and expensive process. Next. So we talk about intestacy, but we can have intestacies occur for a number of reasons. A lot of people think intestacy because the person has no will, but there can be other reasons. You can also have an intestacy created as a result of will invalidity. So a will must be in writing. And if you mess up, have it in writing, you don't have witnesses, there are ways to validate an improperly written will under Section 23 of the Wills Act. If a will is substantially in compliance with the Wills Act, but doesn't fully comply, the court will still validate the will. So I had a situation where a dentist did a homemade will, and he initialed each page, but it was not properly witnessed. We went to court, and the court said, yes, it's clear he wanted to write a will. He just really messed up badly. We see video and audio recordings that people have done. This became the rage when remember VCRs first came out. Everybody was doing a video will on their VCRs. They have been found valid in Quebec, but don't do a video or audio recorded will. It doesn't comply with the Wills Act of Manitoba. The other thing is a testator to do a will must be age of 18, age of majority, unless they're in active service or a mariner in active duty. Well, we don't have too many mariners in active duty here, or people in active military service who are under the age of 18. And the other thing is the witnesses to the will must be at least age 18. So if somebody is age 17 signs a will and their 17-year-old friend signed the will and it's just done, then that is technically not a valid will, because it doesn't even comply substantially with the Wills Act, because the age 18 is a legal requirement of the will, and there's no substantial compliance. Okay, next. Sometimes you might think there is no will, but there is a will. And the Wills Act does cover, under Section 6, holographic wills. So you might think the person never left a will. So we had a situation where a guy was going on a holiday trip, and he bought a Hallmark card at the airport and wrote on one of these Hallmark cards, "If I should die," and wrote some things on it and mailed it. And then he went and he died on this trip. Quite unfortunate. That Hallmark card was found by the court to be a will. So under the Wills Act, if you find a scrap of paper that purports to have testamentary intentions, that could in fact be a will. So there was a case, Cecil George Harris of Saskatchewan. He was a farmer. He was driving an old style tractor with a tiller. The tractor overturned. He was trapped for the better part of a day. They subsequently found him. And while he was trapped under the tractor, he used his penknife and he scrawled on the tractor fender, "I, Cecil Joe Harris, if I die in this mess, I give all to the wife." He signed it, Cecil Joe Harris, Joe, G-E-O. Cecil George Harris was his name. And they found him and they took him into the farmhouse. He was still alive. He then subsequently died the next day, and the family went out, and as they were looking at the tractor, they saw that he scrawled this testamentary intention on this fender. They took up the fender, they took it to the courthouse, and the judge took a look at it, and the judge says, yes, that's a valid holographic will, and admitted the tractor fender into probate. And in fact, that was the base of it. The tractor fender is actually still around. If you go to the University of Saskatchewan, the law school in Saskatoon actually has that fender on display, and they had a big ceremony. The daughter of Cecil George Harris came up from California for the ceremony for it. So it can be that powerful. So just because somebody doesn't have a formal will, it's a good idea to look to see if there is a scrap of paper, because it may be the difference between a will and no will. Next. Oh, I should say about those holographic wills, it has to be entirely 100% in the person's handwriting. So fill in the blanks is not a holographic will, 100% in the person's handwriting. That is one of the legal requirements. So we'll talk about the Intestate Succession Act, and I'm going to make it really easy for you to understand, because for me to get into the actual distribution, so I'm going to talk a little bit about it, but when we actually drill down, it gets a little bit difficult to understand. In fact, a lot difficult to understand. But I'll give you a really, really simple way to understand the Intestate Succession Act. And it's like this: go down, go up, go out. And as long as you remember that, you pretty well got the law there. So go down. So the Intestate Succession Act does not use the word children, it uses the word issue. So issue is different than children. Issue includes all lineal descendants that you might have. So that's children, grandchildren, great-grandchildren, and all the way down, okay? So your issue is everybody below you. Then you go up, and you don't keep going up. You go up to the parents. And then if the parents are deceased, then you go out. So siblings. And then if the siblings are gone, you just start going down. So you don't go up again, then you just go out and down again. And you just keep doing that. And you follow the family tree. In fact, when I used to do these calculations at the Public Guardian Trustee's office. I actually used a very simple software, the Ancestry.ca Family Tree Maker. I actually used that software in the office to do the calculations for intestate succession. So next. So in the Intestate Succession Act, if a person is married, their wife gets everything. If the person is married and they have children, and it's the children of the couple, the wife or the husband, the surviving spouse would get would still get everything. So everything to the surviving partner, or if it turns out that that there's children, it still goes there. All right, next. It gets a little more complicated when we have subsequent marriages, and we see this all the time. People get divorced or partners pass away, and people don't have cohabitation agreements, so they have either a subsequent marriage or they have a subsequent common law partner. And you see in the wording in this is we use the term issue, not children. So if you have a common law partner and one or more of the issue, your children, are not the partner of your surviving spouse or common law partner, in other words, you've got children from another relationship, then the surviving common law partner would get $50,000 from the estate, or 1/2 of the estate, whichever is greater, and then 1/2 of the remainder estate goes to the surviving spouse, and the other half of the estate goes to the children from the other relationship. Very simple way to remember this is if you have, say, $1 million estate, then 75% of that estate is going to go to the surviving spouse, and 25% of the estate is going to go to the children of the previous relationship. Next. The Intestate Succession Act of Manitoba is different from a lot of other provinces in that it uses a per capita basis, okay? Per stirpes, usually in an estate, we have you go by family lines, okay? So let's say you have 2 children and one child has 3 children and the other child has 6 children. If one of your children dies and those children have children, what we do is we divide the estate by the children, and then to the grandchildren, that child's share is divided equally amongst those children. Now, I'll be clear. To be clear about this. So if you have one child and that child has 3, then that child's gets their inheritance and divides it 3 ways amongst their children. If the other child has 6 children, and that child dies, then that child's share, or 50% of the estate, would go to that child, and they would divide amongst their 6 children. It's called a per stirpes division. The Intestate Succession Act says, no, we don't do it that way. So they use a per capita distribution. So for example, they use classes. So instead of this, when you go down these levels, instead of saying we're going to go by per stirpes, we're just going to say how many people in that class and just give one each share. I think this is, I think for the, you know what, I have an example here. I'm going to spend like 10 minutes discussing this per capita basis. Let's move on. I'm sorry, it's a little bit confusing here because of the way the Manitoba law is based, but I have a whole, I'm not going to do it, but I have a whole diagram to show you the differences. And I just think, just know that it goes down to the various families, and it's a little bit different than Manitoba. So just to remember, the important thing to remember on Intestate Succession Act is lineal descendants are issue. It does not use the term children. A legally adopted child inherits the same as a natural child. There can be situations where there's a de facto adoption, and that child does not inherit anything under the will, but we will talk later on in this presentation about the Dependents Relief Act as a manner of bringing in de facto children back into the intestate succession regime. The other thing is there can be children conceived prior to the intestate's death, but born after death, and they are entitled to a share of the estate. Next. There can also be people might have half brothers and half sisters. They inherit, so half blood inherits the same as whole blood children. Also in Manitoba, both under the Intestate Succession Act and the Wills Act, there is no such thing as illegitimacy. The bastard laws of England were repealed many, many years ago. There is no such thing as an illegitimate child. A child inherits regardless of whether they're born out of wedlock or to another mother. It's all the same. They're a child of that person. Okay. Next. With the Intestate Succession Act sets out priorities between a spouse and a common law partner of the deceased. So a person can be married and they can separate, and then they can start a relationship with another person. They could have a child with that person, and then they split up, and then they are with another person and they split up. Well, the question is, if we have multiple spouses and common law partners because of that succession, there can be various priorities. So the Intestate Succession Act says the most recent partner or spouse will have priority. However, if if a previous spouse or partner has a court application going for property division, it's not going to affect that property division. But it's the most recent spouse that will get priority under the Intestate Succession Act for inheriting. Next. Under Section 17 of the Wills Act, if you create a will and the will does not contemplate marriage and you subsequently get married, a will is automatically revoked by marriage. So it is really important that if you're planning on getting married, look, many people, and the standard scenario is people say, no, we're not getting married. We're not getting married. And some reason they go to Vegas and they get married. It seems to be the place to get married for some reason. I guess it's Elvis. So it's, if the will does not contemplate the marriage, then it's revoked. So there should be wording in that will saying that my will shall continue to be valid, notwithstanding any marriage that I might have, to blah blah blah. So you've got to say it in the will. Okay. Common law. We don't have ceremonies when people go common law. So under the Wills Act was actually amended many, many years ago, I think around 2004. So was clause 17.1, which don't bother looking for it because it's not in the Wills Act, but it was actually a clause saying that when you went common law, just as when you got married, it revoked a will, there was actually a draft clause saying that if you went common law, it revoked your will. Now that was never put into the Wills Act, although if you actually look at some of the legislation, it was passed but never proclaimed because of the mischief it would cause. And it's because when people go common law, it just sort of happens. There's no ceremony, there's no gifts. sometimes it's never clear. You ask one person, well, when did you go common law? You get one answer. You ask another person. It's just not so. When people go into a common law relationship, it does not revoke a will, but marriage does. So it's one of the important differences between common law and marriage. Next. So the legislation back in 2000, June of 2004, was a common law part. That was when it was proclaimed Common Law Partners Property and Related Amendments Act. This act is a very powerful piece of legislation. First of all, it gave same-sex partners the same rights as heterosexual partners. And common law partners were given the same rights as married persons. So the general rule, 3 years if no children, 1 year together with children. That's deemed common law, and common law also applies to same-sex partners. Okay, so if you're administering an estate, it is very important to consider that there could be multiple spouses defined by law. So if it comes to giving notices to people to make sure that they don't have a claim against the estate, you might need to talk to or send notices of their potential claim under the estate to several different people. Next. Marriage revokes a will, but separation does not revoke a will. So an intestacy can be caused by marriage, but an intestacy is not caused by separation. And this is an important concept because people think, oh, I separated, and they just leave their will thinking that now the will is a nullity, and that they just can at some later date worry about either intestate succession or doing the will later. But the effect of separation is nothing unless the person's applied for divorce or an accounting under the Family Property Act, or if the parties have already divided their property, say with a separation agreement. So the key takeaway is divorce and separation doesn't revoke a will, and instead the will is construed as if that ex-spouse had predeceased the testator. So they're just struck from the will, and the rest of the will continues valid. So it's not an intestacy situation, which is contrary to what a lot of the public believes. Okay, next. So this is dealing with the common law aspect. So it's equivalent to the marriage part. But one of the things that can happen, and a lot of people aren't aware of, is that some people will register for pension purposes their common law relationship at vital statistics. So if parties separate, if they have separated for a period of 3 years, then that person is considered removed from the will, to consider predeceased, unless they've registered their common law relationship in vital statistics. Then it stays until they register a dissolution. So be very careful about registering a common law relationship. It's done to get people under various pension schemes, etc. But if you do register it, you've got to, if the parties break up, you've got to notify vital statistics that that relationship has been dissolved. Okay, next. So Family Property Act. Well, we know that in Manitoba that partners have right to an accounting from the other part and are entitled to their fair share of the assets. And the family partnership, the Family Property Act, can apply on death. So on death, a surviving spouse does have the right to apply. A surviving common law partner also to have, it's called Part 4 of the Family Property Act, to get an equalization of the assets. on death. So next. Homesteads Act can apply whether there's a will or no will. It stands independent of the person. So this is a standalone piece of legislation that gives the surviving spouse an interest in the marital home, defined as homestead. Applies to common law, and only one spouse can have that right. And remember, I mentioned earlier on that in the Intestate Succession Act, the most recent spouse has the priority. Well, in the Homesteads Act, it's the first spouse or common law partner, the first person in the house, who has the priority. So you have to look to each piece of legislation to see which spouse has the priority. Next. Dependents Relief Act. So I mentioned that earlier on, that people could have de facto adopted children. You could have people very close to you. You could have an adult child living with you. In a subsequent marriage situation, you could have your other spouse's child living with you, who you're very close to. May not be your own child, but for all, if that person, if you've been with that child for a long time, you might consider that person to be equivalent to your child. I know of one friend who, he never had children, but his wife's son, they were extremely close to each other. So the Dependents Relief Act. So I would ask you, first of all, spell dependent correctly. You will notice that it's spelled dependent, A-N-T, not dependent. And there's a legal, dependent is the person who is dependent, okay? So a dependent may be a spouse, a common law partner, a child, a grandchild, a parent, grandparent, or sibling. And the test used under that act is financial need, not financial dependency. So you could actually have, if you had a millionaire father and their kids are all doctors and lawyers, but they're still going to daddy for support, they could technically make a Dependents Relief Act claim against millionaire daddy. It's an interesting test how it unfolds. So if you're dependent on somebody for financial support, regardless of your financial situation, you can make that claim. So it helps correct the moral entitlement of certain children. So for example, you have a child might have been cut out of the will, or a child might not have been mentioned in the will because they were a child from another relationship and that child was subsequently adopted out, but has always maintained a relationship with the family. You see the open adoption situations, for example. And the other thing to keep in mind is that a potential claim can be made by a former common law partner or a child in loco parentis. So in loco parentis, that's means when you're standing in the place of a child, that's where it's not your child, it's somebody else's, the father of the child, but you're acting as that, or your mother, regardless of the family situation. But you're standing in the place of that parent, and you have a close relationship. And if it's a close to parent-child relationship, that child could in fact make a Dependents Relief Act application against the estate. Next. So what does it take to get letters of administration in an estate? Well, it's easy and it's not easy. So I'll give you the forms in the Reader's Digest format. You file a request for administration, and so you say, I want to be the administrator of this estate. And as part of the request, you have to file an inventory and valuation of the property. Now, the inventory and valuation of the property is very important because the court wants to know the nature and extent of that estate, because it's going to affect the amount of sureties or the amount of the insurance bond against that estate, it's also going to have an effect on the legal fees charged by the lawyer under the court tariff. You do now have to provide proof of death. I've always been surprised that we haven't had to do this until quite recently. You need a funeral director certificate or a province of Manitoba death certificate, and you must present the original of that document, and the court keeps it. You need either a renunciation or nomination form. So if you have 5 siblings, each has an equal degree to apply as administrator. So the court's going to want to know, well, which of you is it going to be? Because if there's a contest, the court's going to be asking you to come before the courts too, so the court can determine it. So those who say they don't want to act will sign a renunciation, and would also say, and if there's several people out there, they're going to nominate. So if you say, I don't want to do it, so you sign a formal court form 740, and then you can say, well, my brother Joe Blow, he's really good, I'm going to nominate that person. Okay, you can have different people nominated, then you get into that court dispute. You're going to need, depending on the value of the estate, and there's a whole, the act lists the various values that require different bonds and guarantees and sureties, but you may need a bond from an insurance company or some sort of personal bond. And then for the personal bond, you may need to file an affidavit of justification by the sureties. What that is you have to prove that you have assets sufficient to satisfy any claims that is equivalent to the value of the estate. So if you have a $100,000 estate, you have to prove that to the court that you have at least $200,000 in assets. So you have to file with the court your statement of net worth to prove that you actually have that money. Now, the court may or may not need that, because if the court has a discretion, the people nominating you as executor can waive that requirement. I have had people waive that requirement and had the court come back and say, well, no, even though they waived it, we still want a bond from the people, or we want surety for twice the value of the estate. So it's in the discretion of the court. But the bonds can be very costly, and the affidavit of justification, you might need to have several people step forward and show that, you know, what you're worth, right? So next. So what does the administrator have to do in an estate? Well, the administrator's duties are essentially the same as what an executor would do. So if you're going to act as the administrator, before you even apply, somebody's going to need to gather in and secure the assets. So you got to figure out, you know, if there's an apartment, you're going to have to make sure it's locked up. If there are valuables in drawers, cash and jewelry, in the industry we call cash and jewelry assets that can walk. And assets that can walk, those are the things that are easily stolen, and so they disappear. So you've got to secure any of those high value, easily stealable items. So you might need to fence off something, lock cars, park cars in different spots, but securing assets is really important. The next, you have to prepare that inventory that you're going to be ultimately filing in court. So you need to know the values of everything in the estate. You should consult with legal counsel, because you don't have to, but it's recommended, because legal counsel will guide you through the process, and the legal counsel will assist in your application to court for the letters of administration. After you get the letters of administration, you would pay the funeral expenses. The question is, who is responsible for paying the funeral expenses? Under a will, it's the executor who's got that responsibility, not the family. If you were the administrator of the estate, you would be looking after that. For funeral arrangements, if there's no administrator appointed. There's nobody that can make those arrangements. So usually it's the nearest family member that will make that, the spouse or the children. You have an obligation to communicate with all interested parties, and this is crucial because, as we mentioned earlier on, there could be multiple spouses, former spouses, that have an interest in the estate, and they may want to make a claim against the estate. And you are legally obligated to communicate with all interested parties. And so that is more than just the beneficiaries. It's anybody that might have an interest in the estate. Could be creditors, might have an interest in the estate. I've seen estates where the debts exceed the value of the assets after all the creditors step forward. You need to hire an accountant to prepare tax returns. Tax returns should be prepared and filed within 6 months after death. Then the other thing is you need to advertise and pay for creditors. The reason why you advertise for creditors is if you don't advertise for creditors and a creditor steps forward, they can go after you as the administrator and say, you failed to notify me of this, and I'm going to go after you personally. The advertising for creditors is very important because it absolves the personal liability of the administrator to pay the creditors. Then the creditor, once you advertise, the creditor's claim is against the estate, but not against the administrator personally. Then after everything has been paid out to the creditors, you can now start adding up that net estate. You prepare an accounting of what you took in, what you paid out, and then you can distribute the estate. Okay, so that's in a nutshell. There's more to it than that, but that's a nice thumbnail sketch. Okay, next. Estates under 10,000, those are, you can actually deal with those under Section 47 of the Court of Queen's Bench. Oh, I got Queen's Bench. You know what? I'm sorry. Court of King's Bench. I'm still left in the old world here. Section 47, you go to the internet, download forms 74FF and 74GG from the court website. You don't need a lawyer. Take the completed forms to your local Court of King's Bench, and it's a very simple and inexpensive procedure. You can also apply if people have like a small will or something like that too, but it's a great procedure. Use it if it's a small estate, but it has to be under 10,000. Okay, next. Administration fees. There used to be a probate fee in Manitoba. They're gone. If you go to Ontario, you still got to pay the probate fee, but we're lucky here. All you do is you file the request for administration, and you get it. So no filing fee in Manitoba, gone, which is great. Used to be based on the value of the estate. Next, I see it's we better wrap up now. Legal fees, that's by court tariff. So there's a nice simple format. Court Form 74EE sets it out. First $10,000 is 3%. That's $3,000. Next 400,000, it's 1.5%. That's 5,000. That's a total of 8,000. Next $500,000 is 1%. So you add another 5,000, and over $1 million, 0.05%. You add that up. So that's how the legal fees are based. Although they're always subject to court order or agreement of the parties. Okay, next. That should be it. So thank you everybody for joining us. So if you do have questions to ask, I'd love to hear from you. But just keep in mind that intestacy is primarily governed by the Intestate Succession Act. The administrator has less power than an executor in a will. The person applying must be a Manitoban. There's no authority until appointed by court. All of the acts are constrained by statute, and the process is more cumbersome and expensive than with a will. So thanks, everybody. Any questions?
Thank you so much for that presentation. We do have a couple of questions that have come in during the presentation. If anybody else does have any other questions, now is the time to put them in the Q&A. So the first question that we have is, some people I've talked to with limited resources indicate they wish to write their own wills due to the cost of completing one with a lawyer. is there a resource you would recommend to those individuals that might help increase the likelihood that their will would be accepted by the courts?
Yeah, instead of writing your own will, Manitoba Seniors has a service where they will do wills at a very, very discounted rate. I can tell you those homemade will kits are if you are married to the same person all your life and all of your children are happy and healthy and have a good relationship with you, those homemade will kits are fine. But life is more complicated than that. People have subsequent marriages, children with addictions, subsequent, all sorts of issues start cropping in, and children under the age of 18, disabled children. So it's really like those homemade will kits are they're really, really limited in value. I find that they create more mischief than than helping people, because if you read those instructions absolutely totally cover to cover and you understood them, you could probably do it fine. But nobody does. People buy those kits, they throw the instructions aside and they do it. And I've seen very sophisticated people do some of the worst will kits. I mean, I used to, you know, I did one homemade will kit done by a very sophisticated doctor, and it cost the estate $8,000 to validate the will because of all the mistakes in it. So not a good idea. Go to Manitoba Seniors. They do wills. They have lawyers that they have engaged to do these wills really cheap. I think like $55 or something like that. But doing it on your own, I only recommend it if you've got the same spouse all your life and all your kids are healthy. Okay. But one of the Quicken does a good will kit, by the way. Quicken into it. All right. Don't get
Okay,
the Home Depot cheap one. All right. Okay.
We have another question, not related to wills, but to living wills or healthcare directives. Somebody says, can you explain living wills and creating a living will for situations where individuals may be deemed incompetent? How are these beneficial? And with our current aging population, are there plans in place to assist our seniors and baby boomers create these?
Okay, well, if somebody's incompetent, they can't do a healthcare directive is under the Healthcare Directives Act of Manitoba. The capacity to do a healthcare directive is very low. You need only be age 16 to do a healthcare directive, and it's the capacity is a presumptive capacity, not a legal capacity. So legal capacity would be drinking. So if you go to a bar at age 17 years, 364 days, you are not legally entitled to drink. You've broken the law. But a presumptive capacity just means you presume you have capacity. So a healthcare directive, if you can just show the consequences of making a healthcare decision, you would have sufficient capacity. But if you don't have the capacity to make that, then the Mental Health Act has a regime by default to allow your next of kin, which would be same as the regime under the Intestate Succession Act, to make healthcare decisions on your behalf. There's also, if you need a healthcare decision made and you do not have capacity to make it, the public guardian and trustee can make that decision as a trustee of last resort. But what I would recommend is if somebody needs a healthcare directive, type into your internet search browser, Healthcare Directive Manitoba. You will get a PDF document. I highly recommend you use the province of Manitoba form and not anything out of a kit. Never use a healthcare directive kit, because those healthcare directives are digitized in a hospital. They don't need to be witnessed. So if you look at these kits, they have witnesses and all sorts of like affidavits of execution. You only need to sign it with your ordinary signature. It's a very simple document, and you do not need healthcare instructions in a healthcare directive. The only reason you put healthcare instructions in a healthcare directive is for faith-based reasons. Jehovah's Witness, no blood transfusions would be an example. But you can't direct doctors how to treat you before you've been diagnosed. All you can do is find the names of the people that you trust and let them make the decision in a very dynamic situation. Okay? Get the Manitoba form. Okay.
Okay, it seems like that's all we have for questions, unless there are any last minute ones that anybody wants to put in there. So I think that was a very thorough presentation. We appreciate you being here today and presenting for us. I'm sure everybody learned a lot. I know I did, with wills not being my area of expertise necessarily. I also want to thank everybody who attended today. For those who are asking about low cost wills, I also do want to flag to everybody that CLIA has a lawyer referral program, and we are able to refer you to or give you some information about lawyers who provide wills for a very reasonable price if you are not a senior who qualifies for the program that George mentioned. Otherwise, once again, thank you to everybody for being here. Please do fill out that post-webinar survey if you have a chance after the presentation today. And if there are any other questions or anything else, and anyone can feel free to get in touch with me directly. So thank you very much again, and I hope everybody has a great day and a great rest of the week.
Okay, thanks, everybody. Take care.
Thank you. Bye.